38. People versus Izzo.
Ready for court, please?
Counsel, you want any rebuttal time?
2 minutes, Your Honor.
2 minutes, sure, go ahead.
May it please the Court, I'm Adam Bevilacqua. I represent Vincent Izzo, the appellant. The lower court in this case failed to give the proper weight to compelling mitigating evidence of both statutory rape and mental disability and developmental delay. Also, the lower court improperly scored points under risk factors 3 and 7. Therefore, they improperly designated Mr. Izzo as a level 2 sex offender. As a level 2 sex offender versus a level 1, he'll spend the rest of his life on the sex offender registry.
Tell us about the particular issues that you say they mishandled. What about the webcam business?
Okay, well, regarding risk factor 3,
Yes.
the court is supposed to determine the number of victims. Mr. Izzo is registered for the sex offender registry, lists him as having engaged in acts with 2 teenagers.
Right.
The court decided to find a
Because
third.
of the webcam?
Because there was a particular, there's a passage in the grand jury testimony where someone he was texting with describes a webcam conversation, and it isn't very clear what happened on the webcam conversation.
Well, Counselor, there's Penal Law Section 235.22 sets forth a crime of disseminating indecent materials to a minor, which requires that the defendant intentionally depict or describe sexual conduct that is harmful to a minor through a computer communication system in order to invite the minor to engage in sexual acts. And sexual conduct as defined in that statute includes physical contact with a person's clothed or unclothed genitals. Under that section, isn't it at least arguable that there was a sex offense committed toward this young woman in the webcam?
Well, neither of the lower courts found on that basis, and more importantly, it's not just whether there's some evidence. There must be clear and convincing evidence, which does not exist in the grand jury testimony or the passage that the people and the county court had relied on.
I thought you were arguing that sexual conduct required actual physical contact.
That it requires contact that rises to the level of a SORA-level sex offense, because that's generally what the counting of victims requires.
Can it be a digital crime, then? Or you could never meet the requirements, I guess it's risk factor 3 under digitally?
If the sexual conduct was something that was prohibited by a SORA-level sex offense, then presumably that would be acceptable. That's what the language of the guidelines seems to suggest, is that activity.
I think I see. I'm not exactly sure I do, but I think I understand your argument. Okay.
Okay. Right. The language of the guidelines seems to suggest that even uncharged conduct can be counted, but only if it rises to the level, meets the elements of a SORA-level sex offense. In really all of the appellate division case law, other than this case, that's essentially what they found. The person committed acts that would have satisfied a SORA-level sex offense, but that wasn't actually charged in the indictment. It was just that there was some other person or victim that was found later.
But on that point, before you leave that point, counsel, your position is that the webcam, assuming what was described, if the testimony was clear or accurate, that would not be a sex offense? Is that your position?
Based on what is actually said in the testimony, it doesn't rise to the level of sexual conduct, and there's nothing in it that presents clear and convincing evidence of something that is sexual conduct.
So you're asking us to remit for a downward departure hearing?
Well, I'm asking you to reverse. There's an abundant factual record. There isn't really any contested facts, especially regarding the downward departure issues of statutory rape and
Let's talk
autism
about the
spectrum.
statutory rape exception. Why is that something we should be considering?
Well, the Fourth Department has developed a very large body of
Only the
case.
Fourth Department, right?
Well, but other departments have applied it. But the main case law is People versus Weatherly and Progeny that's been developed in the Fourth Department, and it's completely consistent with People versus Gelati, which this court decided. It's a subtype of downward departure based on a rather common issue of when there's a person who's in their early 20s, late teens, early 20s, and they have sex with a teenager, especially if there's other mitigating factors which are listed. This case.
Well, assuming that there is such an exception, aren't they usually closer in age than this defendant and his victims?
My brief clearly goes over all the established case law from the appellate division, and this case squarely falls within the age differential.
And also, don't they usually deal with a couple, I'll put that in quotes, relationship, an ongoing relationship?
I mean, in this case, that's a matter of perspective in that Vincent, who has mental issues that make him about the mental age of the people he was speaking to, was communicating with them for a while as friends. This was like a date as he perceived it. They watched movies, played video games, and then with one person there was oral sex, and another person he made out with them and felt them.
What's the significance of the developmental disability in terms of the relief that you're seeking? How does that play into the points?
So it explains in a mitigating way why the statutory rape occurred on one hand, and on the other hand, it's a mitigating factor all on its own that's very compelling because there are 3 expert reports that all converge to conclude that he is not a danger of recidivism and that his condition is really developmental delay. It's not something where he's going to have a lifelong compulsion. He's not a pedophile or something like that. He literally developed too slowly.
Under your theory, counsel, at 21, he has the mental capacity or emotional capacity of a 13 or 14-year-old. So when does he become a 21-year-old emotionally and mentally?
That's a good question, but I think for the issues regarding downward departure, it's only relevant to look at whether or not he will progress and whether he has the capacity to.
Well, that's what I'm kind of asking that.
Oh, okay.
You're suggesting that there will be a progression. He won't be stuck in the 13, 14-year-old emotional state. So because you're arguing that he is less of a danger to be a recidivist, if he doesn't progress, then what?
That's something that I'm not really sure how to speculate on. If he doesn't progress after a certain point, what would happen. But the expert reports say that he was very responsive to therapy, participated well. He does have the intelligence to engage in therapy, to better himself, to understand sexually age-appropriate behavior.
That goes all back to why we should you want to reverse, but we could remit to the court to take a look at that?
That's one possibility. The reason why I asked for a reversal is because one of the issues that exists in all of the appellate divisions regarding the application of People v. Gelati is that there seems to be this idea that even if somebody presents multiple compelling mitigating factors such that exist in this case, under the third step, a court can just sort of wave their hand and say, like, well, I don't want to give it anyway. There isn't really any sort of specific application of that third step of Gelati where there's the balancing of the various factors, balancing the aggravating and mitigating circumstances.
You're saying that didn't happen here,
That
right?
definitely didn't happen.
So wouldn't that be a reason, if we agreed with you, just to remit?
I don't know if that would be good enough. I think there needs to be a more...
So you think we should just grant it, even though there's never been, by another court, with the parties in front of them, that balancing? You think we should just reverse and assume that he should be entitled to the downward departure?
I think the facts of the record make clear the arguments that we advanced in all of the lower courts, that the defense advanced in all of the lower courts, and a reversal with an explanation of why would present very specific guidance to the lower courts about how the balancing of the totality of circumstances under the third step of Gelati should function, and how a court can determine whether somebody is a moderate risk or a low risk based on the facts of the record. And essentially that didn't happen in the way it should have in this case, but the record was fully developed in order to allow for that balancing to happen. And under SORA, the appellate courts are given leeway to determine the facts of the case.
Just one final point on this, on what you've referred to as the statutory rape exception. Is that language used in any specific case?
I was sort of.
Or is that your language?
That was my shorthand for not having to repeat
Well,
the
that's
letter.
as I understand it, what you're arguing that in certain cases, courts have exercised discretion when the age difference between the parties involved is relatively small compared to some other cases. But there is not a statutory rape exception. But that's how you characterize the cases where they exercise discretion to do that. Am I right about that?
Under
Or is that in line with the guidelines?
Under risk factor 2 of SORA, there is a very specific statutory rape. That was what I was specifically
I
just
see.
saying. The
Okay.
exception under risk factor 2, which is if the victim's lack of consent is due only to
Okay,
age.
we got it. Thanks. You'll get your rebuttal. Counselor.
Damian Sunsire, Monk County District Attorney's Office for the People.
Counselor, this guy is a very immature, developmentally delayed persona. How does that, isn't that something that should play into these, a lot of these issues in relation to the downward modification? Wouldn't we want to know how really that affects, impacts on some of these points that he's being given?
Well, Judge, first of all, I would say he was a 21-year-old man at the time.
But
He was
clearly,
living-
all the testimony says he doesn't behave like a 21-year-old guy.
He was living by himself, holding down a job,
But all the
driving,
medical
going down-
testimony shows that apparently, do you dispute the fact, that medical testimony, that
I
he
don't
basically
dispute
is
that.
operating the 13, 14-year-old level?
I don't dispute that during the pendency of this case, he was diagnosed with Asperger's syndrome. I don't dispute that.
Well, you didn't have an expert to contest any of the experts.
we did
So
not.
that's, I mean, if the court found that testimony credible, that's, those are the facts before us.
Certainly, if the case is remitted for a fact-finding hearing, that's something that we potentially may get into. When he pled guilty to the indictment, and then obviously we went forward and now we're back for SORA, we submitted on the papers. There was no request for a hearing at that time. And if there had been a request for a hearing, potentially that's something that we would have done at that time, is to have them evaluated ourselves to make that determination from the people's perspective to present to the court. So, but,
You have the burden of proof here.
no, I understand that.
Right?
By clear and convincing evidence, correct.
Okay, yeah.
And
So-
how did you meet that burden with respect to the webcam incident?
Well, the webcam incident, again, the testimony that was presented at the grand jury, the third victim, 14-year-old girl who he had no prior knowledge of and met over the internet on Facebook, she testified that the defendant was touching himself outside of his clothing. The prosecutor asked where, below his waist on his penis. And when he was touching himself, what was he saying? He was saying how I could help him with my hands to fix it and that I would be good at it.
How does that make it a SORA sexual offense?
I don't think it does make it a SORA sexual offense.
You're saying it doesn't have to?
Correct. I think that the defendant and my adversary is advocating for a bright line rule that only a SORA sex offense would apply under that risk factor. And we're advocating for something somewhat more expansive. Obviously, there has to be some factual nexus, I think, between the SORA offense and what we're asking for a separate victim that may not, quote unquote, be eligible for a SORA level 130 crime or something under 265. I think
So
that
any conduct of a sexual nature, would it have to be with a minor, or would you say the
No.
same thing if it was an adult?
No, well, there are a number of cases that, specifically the Klavic case, the Ramirez case from the Third Department, where individuals are present when a sex offense is happening.
Okay,
So-
but this is, we're talking about over a webcam. The two people are not physically in the same location
Correct.
at all?
Correct.
Okay, and so, let's just say that this victim, instead of being a minor, was a 20-year-old woman or a 25-year-old woman. Would she be a victim?
No, I don't think so.
Why not?
Well, she would not be, I mean, first of all, it wouldn't even have been part of the indictment, most likely. She was charged, the indictment charged on endangering and an aggravated harassment. I don't think if it was, I mean, you could potentially have an aggravated harassment just on that, depending on their previous relationship. We'll just assume for a moment that they're complete strangers and this was happening. If that was the case, then you may have some type of case. Again, I think there has to be some way for courts to be able to analyze this information and potentially to include those quote-unquote victims in this risk factor, because it can't just be that if it's not SORA, we don't care.
Is it because he was inviting her to participate in some kind of sexual conduct?
Well,
that makes that webcam communication, for lack of a better phrase, something that fits within the guidelines for scoring
I
purposes?
think it's because there's in my mind, a factual nexus between the SORA victims in the first dozen counts and this girl. And the factual nexus is the fact that he was contacting all of them on the internet, started with Facebook, moved to phones and text messages, and then did in fact invite them, which he was doing with this girl.
The contact only matters to the extent that it has some sexual aspect to it. And the
Certainly.
question is, what does that mean for SORA purposes?
If
that
he's
sexual contact?
contacting her and saying, let's play baseball, we're not having this conversation. But he's not. He's contacting her and having
I want to have sex with you.
very highly sexualized. And she testifies at grand jury that he buys her fuzzy handcuffs, a kinky outfit.
Mm-hmm.
When the case breaks and the state police are investigating the case, the state police investigator is texting the defendant from her phone. He thinks he's communicating with her. He's saying, I have condoms. He's saying, come over. Don't worry, you're not going to get pregnant. So all of this in totality, I think, makes it very clear that this is a highly sexualized conversation and contact with a 14-year-old girl.
Going to risk factor 7, which is sort of follows from this, what is the clear and convincing evidence that these online relationships were started for the purpose of victimizing?
I think it's very simple. The first time he had contact with the first two victims, a 13-year-old girl and a 14-year-old girl, the first time they ever met face-to-face, he sexually abused them.
And that's enough?
Yes. That's enough. He doesn't go to the mall to have pizza.
So he
doesn't go to the-
he was grooming them
Clearly. I mean, what else was he doing?
with a 13 or 14-year-old mind. He was grooming them.
Again, Judge, I don't dispute that during the pendency of
I
this
thought these
case,
first two talked online for like a month or two.
at least that long, correct.
So
they're not strangers.
But we don't know if there's anything in those emails or whatever they did that was related to sex, do we? Or we don't know the context.
We don't know that.
Okay.
No, we don't know that.
So how do we know? I mean,
We know because, I think this argument becomes a lot more difficult if he meets these girls and they go to a ball game and they have some popcorn together or go to a movie or something. He sends a cab to a local park to pick up a 13-year-old girl to bring her to his house, and he has oral sex with her, first time they meet. The other girl, he sends the cab to a mall, brings them to his house.
Different girls?
Two different girls.
The point is that wasn't the expert testimony that he could not form the necessary intent to groom? So regardless of what was going on, he did not have the intent to.
That's what their experts.
And do you have
Yeah.
anything that refutes that?
No, we did not. Again, we did not get into a fact-finding hearing before the judge. We did not have our own experts
But even the way
evaluate
he's
him.
doing this, the things that you're talking about, sending the taxi to the mall, this is not a sophisticated guy grooming these young girls.
I would disagree, Judge.
You think
this
that
is
this is
fairly
all with an
sophisticated.
emotional, calculated
Yes.
investment in grooming these young girls?
Yes.
If you
Yes, I
know,
do.
if there was somebody that every day was going by a fruit stand and taking an apple, and you wanted to charge them with 3 counts of petty larceny, and somebody said they don't have the mental capacity, they didn't know they were stealing, they were just taking an apple because they thought they were entitled to it, you would lose the case because you couldn't show the appropriate intent. Here, you can show all the facts that you say add up to an intent to groom. All the facts are there, but this person cannot form the intent because of his mental condition, and there is no evidence to refute that.
Well, I think there is some evidence to refute that because the record.
I asked you and you said no.
Well, I'm thinking about it more, Judge, and I'm going back to the same point that I made
Okay,
earlier.
go ahead.
This is a fellow that was living by himself, was holding down a job, was taking college-level classes, had a driver's license, had a computer, was sophisticated enough to utilize the computer to latch onto these girls and draw him into his
Counsel,
home.
are we only dealing with this grooming issue because there was some contact or a lot of contact with these young ladies before they actually meet? What if there had been one contact before they actually meet and then?
Well, they would be strangers.
They would be strangers,
Correct.
okay.
So, I mean, that risk factor, and they're not strangers because there was some contact going back and forth. But I go back to the same
How
point.
much contact? That's what I'm trying to get at. How much contact takes them out of the stranger category into the friend category and then grooming category? That's what I'm trying to figure out. Would it be
There's a
3
body of case law that we really didn't get into in this case because I think everybody agreed that they were not, in fact, strangers.
No,
They
no, no,
had
I understand
developed
that, but I'm just, assuming they were friends, I'm just trying to figure out on the back end, how many contacts would constitute grooming versus just, he meets them, for the first time, they've had a few conversations either over the internet or, they're tweeting or whatever they do, and then there's sexual contact.
Well, again.
Where's the grooming? That's what I'm looking for.
Well, again, the grooming is this contact. He is developing a trusting relationship, trusting enough for these girls who are.
Yeah, but
he
may
doesn't
not,
know.
He
but
may not
for,
be capable of doing that. That's what we're saying. That you're interpreting this, but ignoring the medical testimony that's come in. Don't we have to assume that that's uncontested and that it's not so obvious? That that's what he's doing, and when you combine that with testimony that seems to make clear he's not capable of that kind of calculated conduct.
Well, again, Judge, I respectfully disagree because I think the record shows that he is capable of that calculating conduct, and one of the major factors. Despite the medical, and one of the major factors I bring up is his term on interim probation. And what did he do while he was on interim probation? That lasted all of 4 months. He purchased a computer when he shouldn't have, got onto Facebook under an assumed name of Vincent Civilione, and started contacting girls up at the Corning Community College.
It's intent to groom. I understand all of that. One of the concerns I have, if no one else is, we slam these people routinely. These are tiring. We don't like them. I'm speaking as judges. He was in jail for bad things. We're going to soar up. We'll soar a 2, so it's not a 3, and we're done. And we're not going to waste our time with these things. And every now and then, you get a dolphin in the tuna net, and you got to make sure that what we did was correct. That's, I think, why we have all these questions and why the dissent raised this grooming issue in their.
I understand, Judge. Again,
Would you, just one other thing, would you agree that the courts below did not engage in that third step weighing process?
The lower court's decision, county court's decision, Judge Hayden, it was a 12-page decision. It was fairly well-rounded.
Well, it was very extensive, but
Yes.
did it ever get to that step? I mean,
He doesn't explicitly say in a paragraph the court is weighing these mitigating factors. No. But I think in the overall dozen pages of the decision, I think the court does go back and forth.
Would it be helpful to have it sent back for that kind of weighing?
I'll leave that for you.
Okay, fair enough. Counsel, rebuttal.
Thank you, Judge.
Thank you. Counsel, was there a weighing in terms of the requirements here?
There was not, and actually,
You look at the totality, did they do a weighing analysis?
They decided, the appellate division, their department decided the downward departure issue by saying there wasn't a preponderance of the evidence of any mitigating factor, which the people now concede in their brief was erroneous, and they're asking for you to weigh the third step. So the appellate division committed error just on that regard. But I think the issue of the dolphin in the net is actually important in the sense that there is this sort of issue of automatically labeling people that have been convicted of sex offenses and not really giving them the sort of protections under SORA that they might be entitled to in other areas of the criminal law, because SORA has been, sort of classified as regulatory. But the difference between level 1 and level 2 is vast, and there are punitive aspects to it, which I don't want to get into the punitive regulatory issue today, but having clear guidance on how to balance the totality of evidence, specifically with downward departure, is important.
What exactly, you said that on your initial case, counsel, what exactly would you suggest that we tell the courts about the balancing?
Well, I
We
think
haven't already told.
I think Gelati goes halfway, and I want to go another 50%, I think. Or I would ask this court to go another 50%, which is Gelati makes clear that downward departure is like a type of affirmative defense, where once certain evidence has been proven by a preponderance, then there needs to be some sort of rebuttal by the people that is proven and that negates the mitigating circumstances, and then under the totality of evidence proves that the person is not, in fact, a lower risk. For example, if the defense proves that the offender is a low-risk offender with these mitigating factors by a preponderance of the evidence, then it is incumbent upon the people to either disprove it or advance other evidence that shows that they are, in fact, a moderate risk instead of a low risk.
The judge seemed to spend an awful lot of time on this case, and it's a rather thorough opinion. Is there something in the opinion that you think is wrong?
In the county court opinion,
Yeah.
most of that 12 pages is just reiterating the arguments of the two sides. Very little of it is actual analysis. Thank you.
Okay, counsel. Thank you. Thank you both. Appreciate it.
All please rise. Hear ye. All persons having any further business before this Court of Appeals, although for the State of New York, may depart hence and appear here Wednesday afternoon at 2 o'clock, which time this court now stands adjourned.